Hey everyone, welcome to the first episode of the Tech Law Forum podcast from Nalsar. I'm Belinda and this is my co-host Bharati, and we're excited to bring back the forum to life after COVID to have some conversations about life, tech and law. For our first episode, we'd be chatting with Shrutanjaya Bhardwaj from Pravah Law. And some of you may even know him from his own podcast, Law Varta, where he interviews successful lawyers and their pathways to sort of make it transparent for other young lawyers. Through this conversation, we aspire to delve into the quirks and principles that shape his approach to tech law, exploring themes like the technology's role to justice, an Indian framework for tech regulation, and trends that inspire hope for India's future. So, we're recording from the Nalsar campus, where Shrutanjaya is visiting for the Courts and Constitution Conference, where in the morning he moderated a panel on digital freedoms and tech law. So, with that, let's dive into a genuine conversation about ideas that matter.
Thank you so much for agreeing to be with us and
Thank you.
for hosting for helping us with the first episode of the podcast. And so we like to begin on a more personal note. We're very curious about how you ended up in this practice. So both as a lawyer and as someone navigating the landscape of tech law in India, we want to hear about your personal experiences that have sort of shaped your understanding of the intersection. What connections drew you to this intersection of tech and law, and how you sort of just end up featuring on so many panels about, digital freedoms and tech law, because I understand that your practice isn't only tech law, right? So, yeah.
Yeah, no, you're absolutely right. I have no idea why it's featuring on so many panels on tech law. I think my interaction with, so first of all, I mean, the words tech law, they sort of connote that there is a distinct branch of law that deals with technology, which is a little inaccurate, because we usually use the phrase tech law to refer to a bunch of laws that concern technology, but when you actually study those laws, you're actually approaching it from a constitutional law perspective or a criminal law perspective, something like that. At least that's how I like to look at things. I generally, the general level, I try to avoid clubbing subjects of law into areas like, I don't want to give examples, because that sort of, many people sort of say we practice an area of law, B area of law, and doesn't really give a very accurate picture. Sometimes just, commercial law broken into five sort of sub themes. And that's fine for the purpose of categorization, but I just want to flag my understanding of technology law is just some legislation. You have the IT Act, you have the Copyright Act, often you have rules made under the IT Act and the Telegraph Act. Now the new telecom laws are coming in. So that bunch of laws are collectively referred to as tech law. And I'm not neck deep into tech law as many others are. I'm not somebody who practices this on a daily basis. I actually, most of my practice is service law and criminal law and constitutional law, which is traditional sort of constitutional law. Some IP and some sort of property law. But in all this, there is always some aspect of technology that is now emerging. And really, going back to what I said earlier, I think technology law is just all these traditional areas of law now starting to interact with new phenomena when it's technology. I started off, I think my first exposure to this may have been in a moot, which is the Oxford Prize Media moot, where the problem is, every year the problem is invariably somewhere about fantastic. Yeah. Fantastic. So every year it's about some social media intermediary that is either failing to take down some content or has taken down some content, and the government is now coming after them or something. So that, I did that moot in my fourth year, and I was very, very interested in that subject area. And since then, every year I've been sort of associated with the moot in some capacity. I'm either judging or coaching or part of the organizing in some way. So that touch hasn't sort of lost. That may be one reason why people sort of keep calling me to these things, because they know I understand it. That may be one reason. But apart from that, I've had chances to participate in some litigations here and there about which are not really solvable without understanding the underlying technology. And this can happen in a very simple NBPS bail case, as much as it can happen in a copyright dispute, on how technology is accelerating. Somebody used a very good word today in today's panel. Technology reduces the friction that would otherwise exist. So some things like infringement are made easier, or me accessing paywalled content is becoming easier. So therefore copyright law now has to struggle with some kind of existential questions. Like, is it even possible to enforce copyright anymore? That's one of the questions that copyright law has to ask itself and answer. But yeah, so these are things that I got pulled into, sometimes because of my seniors with whom I was initially working as a litigator. Later, because some people would have thought that I understand the technology and wanted some extra help on that matter. So then they sort of asked me to come in. But yeah, it's all by chance in that sense, and it's by chance that I'm sitting here.
Just a follow up to that, obviously without damaging any information that you shouldn't. Like, is there a particular case or policy paper or some work that you said wasn't strictly about tech law, but you were roped into because you understood the technology, something like that? Is there something interesting that comes to your mind there?
Two copyright cases immediately come to mind. One is I can take the names of the cases. I don't think that's a problem. One is the case concerning Sci-Hub and LibGen, where basically there's a copyright infringement claim against them, because the argument is that paywalls are being broken and copyrighted content is being made accessible. That is one litigation I'm doing, and
it's ongoing.
It's an ongoing litigation. It's been pending for some time, but so exciting as a field to navigate, especially because the other side is a sort of a seasoned senior counsel, seasoned IP firm who know a lot about IP generally and also understand the technology. They're also very, very competent. So just every hearing is such a good sort of learning experience for me there. And second is now the ongoing suit in the Delhi High Court on OpenAI GPT.
You're involved in that.
Well, we had a chance to intervene, and we are yet to know if we get to argue there. But it'll depend on how the hearings proceed. So these are some cases where somebody thought that, okay, I can understand the technology and help on the matter, and therefore I'm on the matter. So and so some other matters that I was involved in are the Supreme Court and Delhi High Court level about WhatsApp and Facebook and their privacy policies. Should you have a change in the constitutional doctrine that we don't enforce fundamental rights against private players? Should you change that?
Right.
So there was some litigation about that, and I was also fortunate to be involved in that with my seniors.
That's very exciting. Yeah.
We're also interested in how you sort of see technology changing the fabric in India, right? So you've also spoke about accessibility in courtroom discussions in one of your articles in the Journal of NLUD, right? So within this linguistic framework of diversity and the sort of fabric that we have currently, how do you think, or do you think technology will help in that space, and especially with AI also coming into frame? So how do you sort of think that would affect accessibility and justice?
Yeah, no, there I think technology has tremendous potential. Of course, subject to somebody having the intent to build that technology, which so far hasn't come forward very promisingly, but I'm hopeful that somebody will make something that makes it seamless for a judge who may be a chief justice of a high court in the Northeast, having originally come from a state down south, who may not understand the local language of the state in which he's currently serving, but he's the chief justice. He or she is the chief justice there, and it's impossible for some matters to avoid that judge. And there may be a litigant who insists that I will argue in my language, and I am hopeful that there will be some technology at some stage that makes this kind of argument seamless and without any irritation, because I don't want to overlook the fact that courtrooms are very high pressure settings, and everything is happening very, very quickly. So before you can speak the next sentence, the judge has already made up their mind about what you said previously. And you don't want to lose any sort of time because the technology is, because you're waiting for the technology to give you the accurate translation. But yes, now with more powerful technology coming in, I'm hopeful that something like that can be solved. And maybe more importantly than that, I feel the biggest or the most embarrassing part for all lawyers and judges, if they want to share the embarrassment because it originates from them, is that our judgments are terribly written. And if we just go back to Privy Council judgments or the early Supreme Court judgments, we see how top quality judgments are written about the gravest constitutional issues with such brevity. It's amazing to see 3-page judgments laying down an authoritative proposition. Somebody was mentioning Kati Kalu Ogre today if you see the length of the judgment, it's shocking. You can't imagine an 11-judge bench sitting today writing such a short judgment. There are only 2 judgments in that 11 judges. 10 judges are writing one judgment, and there's one, I understand, a separate but concurring view, no dissent. So, I mean, if you really have that kind of a setting today, I doubt you will have such a short judgment. So, the way technology can help in this is, I think, at the stage of judgment writing, it can help judges really distill their ideas. I can understand why judges may not have the time to write shorter judgments. It really takes a lot of time to reduce what you want to say, to avoid repetition, etc. And there, technology can help. It can sort of be a ready tool for them to sort of put in whatever they want to say, shrink it, and then yes, they'll have to put in that extra effort the initial few times to ensure that the technology is working correctly. But that I hope some judges will be able. That will really help just enable people get over that initial inertia of reading judgments. Even lawyers and law students don't read judgments because how does one read 400, 500-page judgments every day? It's a little tough and hard to expect people to do.
I have a quick follow-up to that. So, I mean, one thing with the legal system, not just the judiciary, but also lawyers, I find that, okay, one like silly reflection of that is like, let's say the black robes that we still like very particular about. But I find that the legal system is quite reticent about adopting new practices and new methods. Even now, the iPad, digi notes thing that like most lawyers use, it took a long time, right? Like young lawyers, sure, like began using them straight out of college, sure. But it took a long while for lawyers to adopt that, even though it makes their life so much easier, they find now. So in that sense, what do you think, are you actually like hopeful about this happening anytime soon? And also the fact that if it's a third party software, the whole issue of confidentiality and putting court records there, right? How would the system, sort of have to look at it? What are some considerations?
Yeah, so let's break that up into 2 parts. One about, we'll come to court records and confidentiality later. Yes, I am hopeful, mainly because the only real block I see in this transition to a sort of a paperless court is habit. That's really the only roadblock, and many judges have given up their old habits. There are, although a minority of judges in the Supreme Court also. In the Delhi High Court, you'll see virtually every judge who's maybe even not virtually, actually every judge who is only using soft copies. Originally, the system of soft copies was a little problematic in the Delhi High Court, from what I understand. They used to print out all the copies, then scan everything, and then send it, which sort of defeats the point. But I think they have now moved to a much smoother system. And actually, you can see its effects on the daily lives of lawyers and judges. Any lawyer who practices both in High Court and Supreme Court in Delhi, like me, would tell you that if you were to ever decide, if there was a matter that could be filed in both the Delhi High Court and the Supreme Court, and you wanted urgent relief, everybody would, without blinking, say just go to the Delhi High Court, because the time it takes for a matter to be filed and listed
Process.
is 1 day.
Okay.
I mean, I'll file the matter before 11 o'clock, before 12 o'clock today, right? And it'll get listed tomorrow in court. Of course, I mean, I'll have to ensure a minimum sort of a standard of the filing. Basic defects have to be sort of taken care of. And the registry may mark some defects, in which case it'll get pushed to day after tomorrow.
Right.
All right. And Supreme Court is just terrible. I mean, it's 2 weeks, 3 weeks, 4 weeks, keep waiting. There are systems in place, and every Chief Justice tries to improve some way of getting these matters listed before the court. But the real reason why things are not happening so fast at the Supreme Court, according to me, is because printing is still happening. There is no printing in the Delhi High Court. They take your PDF, they check your PDF, they forward your PDF to the court, and that's it. Which doesn't involve one person picking up a stack of files from the registry in the dungeons of the Delhi High Court up until the second floor.
It really is a dungeon.
It is a dungeon.
Yeah.
And nobody is traveling physically, taking a trolley up to the Chief Justice's court to give all the files, which is happening in the Supreme Court. And until those files come, work can't start. The law clerks can't start preparing the brief. You will not know what is on court record because you'll have to physically inspect the file. Now, of course, there is a new system. So slowly things are improving, but the Supreme Court is really lagging behind the Delhi High Court in that sense. And yeah, my sense is I am hopeful, but it's just a thing of old habits. And I'm sure as younger and younger judges will become older and older and occupy these positions, they will be quicker to adopt these technologies.
If I can sort of take you a limb back and ask you a question. Recently, even the courts have started recognizing ChatGPT and other AI tools as search engines itself. So, like, as you talked about brevity and accessibility in judgments being really important. So, in that sense, do you think these tools might sort of affect judicial reasoning, or I mean, these are tools that can, like, are they supposed to be used for enhancement? What do you think? Or do you think there should be a sort of ratio up to till when they can be used and how they can be used as well?
So, yes, in the sense that the judge has to apply himself or herself. It can't be that the task is outsourced to the AI tool, whatever language model you may use. But large language models like ChatGPT are extremely helpful in some things. Like I mentioned, if they want to really reduce the clutter of the judgment, if they want to better organize their judgment. Sometimes it happens to the best of us that we are writing a legal argument on a piece of paper and then there's some, what they call a brain fog moment. I can't understand how many points I have made in this 2-page passage. And then you run it through your large language model and it tells you that according to me, I can see 3 broad points. And then if you put it like that in your judgment, of course, the judge has to once again revise it to see if it's accurate. But just those small helps, pieces of help that can be offered to a judge are, in my view, extraordinary and should be used as much as possible. Not only that, if some judge is unsure about the reasoning that they are adopting in a particular case, you can ask the large language model, this is the argument I'm taking. It's all about prompting, right, with these large language models. So you say that, think like the most critical person on the planet, poke holes in my argument, give me 5 reasons why the argument is wrong. And to really test your hypothesis as a judge, which is very important for a judge to do. And it can only be done when you have resigned to your chambers and you're writing a judgment, which doesn't happen in most matters in the Supreme Court, but it happens in a significant number of matters. So if they can use that tool to improve their own thinking and push themselves a little more, I'm sure they'll also find it more enjoyable, the task of judgment writing. And so sort of sometimes the lawyer may not have put forth their case as powerfully as a large language model can instantly sort of decode and present it before a judge. Sometimes it can be the other way around as well. The lawyer can obviously do a better job, but yeah, just to make up for it, just to make sure justice is being done and I'm not punishing the party for a lapse on part of the lawyer. I think that's helpful.
So just because you mentioned getting the LLM to poke holes in your hypotheses, have you done that? Like when you let's say you're unsure about something that you're about to present in court, or like how do you utilize AI, or even not necessarily AI, like in your personal practice, how has technology helped in your...
So I've definitely done that many times. I've done that not really so much for court drafts, mostly because the amount of time you have. Often the situation is such that the client wants it out, and these things don't occur to you. But even for court drafts, I would have done it at some point. I've done it definitely at a later stage when I'm running a thought. And I all you need to do is tell the LLM that this is the provision of law that I'm dealing with. And sometimes the kinds of problems that you run into as a lawyer are also unique. Sometimes it's funny, and sometimes the provision is just drafted so badly that it doesn't make grammatical sense. And now the court is called upon to decide whether I should interpret it as east or west. And if it's east, then you go to jail. If it's west, then you're free. So it's a serious issue. It's not one of those things you can. And to break that down, sometimes I may be thinking that's grammatically incorrect, but it's not. And I put that through an LLM and say, will you break it up into its components and tell me what this really means and in how many ways can it be interpreted? And sometimes it can give. Sometimes you'll just find that it's a waste of time. I already thought of all this, whatever it's telling me. But sometimes it may give you something that is very useful. Yeah, but I keep using it for a number of things. Difficult, not really for arguments, but sometimes you just can't find, like I said, the best way to articulate a particular thought. And you might want to. I've actually never found that the LLM will say it in a way that is to my satisfaction. But it
first draft.
Yeah, it can definitely give me rather I'd say a second draft, because I give it a first draft. And then give me a second draft that's better than my first draft.
It's a process of enhancement.
And then, but when I see that second draft, I instinctively know what I need to change in this to make it sound perfect, at least in that moment.
Right.
So that, it's invaluable, and really it's tremendous technology, and I'm really sort of awed by it.
Okay. Slightly on a different note, this morning's panel, I found that multiple speakers kept highlighting how there was a sort of way of thinking in silos when it comes to, as you said, again, technology law is not a singular entity, right? So in how principles of criminal law and constitutional law can complicate our understanding of rules and bills and draft bills and amendments in technology law regulations. So just going back to first principles, why do you think that even as students, practitioners, as well as lawmakers, and then finally the judiciary, there is a fragmented understanding of how these ideas are actually, they're part of the same thing. You're regulating, at the end of the day, human speech or human action. But when you suddenly say, oh, this is a technology law case or a privacy rights case, it takes on a different color, and then you get lost in the technicalities of it. So I sort of wanted to ask you, how do you think we should start thinking about it? How do you think we should start thinking about it in school itself, in college, at law school?
Yeah, it's a difficult question to answer for me because of the breadth of the question. But See, yeah, according to me, it's not the right way to think about any law, to believe that this is something different from and not connected to. I mean, it can be different in some material ways, but it's not disconnected from what you do usually. And ultimately, all these disputes land up in courts.
Yeah.
You're arguing before judges and you're arguing against lawyers who have been trained to think a particular way about the law. And that's not going to change. We are all, I mean, our training as lawyers is essentially grounded in a process of legal reasoning where we read the text of the law, we try and understand the meaning of those words, we see if there's any judgment delivered on those texts. We take the help of commentaries in this process. So that's the way we move forward in these things. And now, of course, there are more and more statutes which are specifically concerned with regulating technology. But at the same time, you'll have, like I mentioned, copyright law, or there'll be some provisions in the insolvency and bankruptcy code. Find even in sort of other usually considered traditional fields that some provision will be added. Like you had the Evidence Act suddenly being amended to include an electronic evidence certificate, which nobody had seen before. And now the format of that certificate has been changed by the new sort of Bharatiya Sakshya Adhiniyam. So everybody is sort of struggling with how the hell do you find a hash value of an email, right? Now, these are things that will keep happening with laws because these are new phenomena. And as the famous Supreme Court, US Supreme Court Judge Justice Kalia used to say, there is really what I'm asked to do is extend existing principles to new phenomena. And that's how I would encourage everybody to think about new technology also. There is, of course, new legislation, in which case it has to be read, text has to be read, the same process has to be followed. But the minute there is a constitutional challenge, for example, you can no longer rely and keep repeating the technological aspects of it. In fact, I remember during the Aadhaar hearings, the judges got extremely irritated, both during the 9 judges Puttaswamy and the 5 judges Aadhaar, with a lot of counsel, only because the counsel kept harping on what the technology is. And the judges, I remember one of the judges telling one of the counsel that it's been 7 days since we are hearing this matter. We haven't heard the words Article 14 from you. And can we now please tie this down? What is the doctrine under Article 14 that you're invoking? Then go on to the facts to understand what's because all judges think like that, and they should. In my view, that's the right way of thinking about things. There is a constitution that governs us. If it's a constitutional challenge, that's the starting point. The starting point is not, the grand ideas of technology. You have to really be able to break it down into simple terms and explain it to the court. It's a very tough thing to do, even for the most seasoned counsel. Not because they are not capable, but inherently it's a very difficult thing to do. To explain something that is so complex, break it down into simple terms. And sometimes when the generation gap is so huge between the and when the judges may be of a background that their understanding of the internet itself is minimal, and they feel surprised when something appears on the internet, to now expect them to understand nuances of artificial intelligence. You really need a good teacher, in that sense. It's like teaching a student, and judges are very, very receptive. I've seen that extremely humble individuals usually sit on the bench and they really want to know and learn and what's happening, and they're taking notes when everybody's talking. But it's just that ability to break down a very, very complex thing into its simplest components and put it across to the bench. This is what it is. There's nothing more. The information is stored here. From here, it travels here. Use maps, charts. Especially when you're a senior advocate, you have all these liberties in constitutional courts that sometimes when a junior lawyer does it, court may take it. The court may just feel like he's trying to stunt. Like if I do it, some judge may think that okay, he's just wasting my time. I mean, they may. I don't blame them. I mean, I don't have that kind of an equation in their court I may not have appeared, in their court for 20 years
Yeah.
continuously, so they
Yeah.
may not have that faith in me.
Yeah.
And then as a senior advocate, they will have that faith in the senior advocate. So yes, they have those extra liberties, and they should. They've earned those extra liberties. But with it, I think comes that responsibility that if you have those liberties, please use them, and please really drive home the point in very, very simple language. Don't. There's a tendency to quote authors of the West and great thinkers before coming to the point. That's just that's something actually I feel passionate about.
And also with, I think, technology, like jargon can get really can get really like intense, right? So I guess like even my own dad, he's a lawyer, but he gets really scared when I use like words like, I don't know, data set training. He's like, what does that even mean?
Yeah,
right?
and I don't. I actually.
You can't blame them at
Yeah.
all. Yeah.
In fact, I blame the people who've come up with these terms.
Absolutely.
It's not the engineers. I mean, they understand these terms and they use it in their daily lives. It's like keeping a name for a human being or for a thing. You want to keep names for things, and I understand why you may.
Christening them, yes.
You may just for convenience want to call it a data set. Everybody understands. But when lawyers pick it up, they really need to be able to. That's their only job. Lawyers exist because people are hired as counsel because of their ability to explain things in extremely clear terms. That's why that's the biggest selling point of any lawyer. Whether you're doing it in writing or you're doing it orally, and that's why I feel the blame lies with lawyers who just don't take the effort of really understanding it to the core and breaking it down.
You sort of brought up the US Supreme Court justice and what they were saying. So, sort of in that context, do you think that there is a distinctly Indian approach to technology law? Or is that sort of not, have we not developed to that point yet? Or like what does it look like in practice and theory, the Indian framework? Or is there a distinctly Indian framework at all?
Yeah, no, definitely there's something called an Indian framework for technology law. Once again, I mean, assuming there is something called technology law, you can always identify an Indian framework that is driving it, mostly because of the constitutional law principles that are unique to our country and the principles of statutory interpretation that we may use. And usually the principles of statutory interpretation are identical in most common law countries. They use the same principles, and we use authorities from across the globe also. And we're trying to understand the statute. But nonetheless, I think Indian judges have their own way of emphasizing a particular school of thought over, like, for example, you'll see in the US that there's a huge divide between the living tree sort of approach to the Constitution versus a very originalist. Justice Scalia being one of the foremost. And you may disagree with him, but it's really, really compelling the way he made his case. He's no more. But I mean, he's that kind of a divide that you see in the US Supreme Court, you barely see in India. I mean, I don't think anybody seriously contests the proposition that the Constitution is an organic document and we will keep interpreting it in new ways as times change. And similarly, they hold about statutes now as well. In fact, our equality doctrine embodies a principle that a statute which was compliant with Article 14 when it was made can turn violative of Article 14 with time. And that kind of, I think that's like a nuance. I don't know of foreign jurisdictions that also adopt this approach. Maybe it's my ignorance, but I'm not aware. So there are these nuances, and every time a technological issue comes up in the Indian context, when it is being litigated, for example, in the Delhi High Court or in the Supreme Court, like some of the cases I mentioned, it won't help us much to use foreign sort of judgments in these contexts. And it happens. I mean, many people use foreign judgments, but the judge is quick to remark that, we have to be very, very circumspect while using this because the law they are interpreting, the law we are interpreting, vastly different.
So you've already spoken about how you'd like a system where, a justice from the Northeast could, like, a frictionless translation and, not translation, sorry, in terms of courtroom. So other than the judiciary, is there, if you could redesign just one bureaucratic process, or even like not just on the government side, but like, for instance, like Yatra, is one example of like DPI. Like if you could redesign like one process in our daily lives of the, like that government is like, okay, you have to do this to, walk and talk the streets. Or even just the simple act of like going to what is the office? What- the look. Okay, whatever. The point is, if you could redesign one bureaucratic process in India that does not relate to the judiciary or the like legal profession as such, what would it be and why?
It's a very hard question. I feel that practically all bureaucratic processes can be so technology will have its levels, right? So you'll have like a basic level of computerization that can immediately eradicate like 20 problems that the government might be facing or the people might be facing. Corruption, loss of files, something got burnt in the cupboard. You just put computers and put everything on computers, then many of these problems will just disappear overnight, right? That basic level of computerization we are a long
Still
way
can't. Yeah.
away from. I live in Delhi, and one assumes that being the capital, it will reflect a level of advancement that other cities are yet to achieve. And even there in Delhi, it's really, I mean, electricity department or some water department is generating bills for people. When you go and question them on those bills, they give the impression that everything is computerized and everything that's been generated is just automated. But the minute you ask 10 questions or whatever, some basic questions about where is my meter, what was the reading, etc., suddenly these handwritten notes will come out. And that it's all ultimately stemming from. And the reason is not, once again, the blame doesn't lie with them. The blame is about, it's a collective sort of societal blame for not pushing technology as an essential part of education everywhere. Our comfort level as a society with technology isn't up to the mark, according to me. And it should be. The reason we have some very, very avoidable scams like digital arrest or whatever, these new things, is just because, we don't try to develop that comfort level with technology, that people would be actually curious to dive into to one smartphone to understand why something is happening in a particular manner. Just if those things, those habits can be inculcated, I think a lot can be solved. But yeah, if you ask me about a specific bureaucratic problem, I'm not sure I can name something like that. But really, something that comes
covers
to
everything.
me, something that comes to me is now two things, because recently I was doing something that suddenly these things came up and they irritated me. One is the way they deal RTI applications. Now, you'll see that many government departments have now started taking a specific kind of objection to RTI requests. So suppose you ask, please give me the documents by which a particular employee was transferred from A place to B place. They may either give you the document or say that it is covered by one of the exceptions, privacy, etc. But if you say stuff like, has this government servant been transferred, right? Now, if your document exists, and suppose you would have given that document if the question was framed in the first manner, the department is likely to say, and I've seen many, many responses across departments now, because of the diversity of cases, I can say this with confidence that it happens across the board. The answer will be, what you are asking for doesn't fall in the definition of information under the RTI Act. Right? Because according to them, the definition of information under the RTI Act only refers to documents. So you frame your question as, give me a document. They will have to engage with it. Either they will have to say, yes, we have it, here it is. Or they will have to say, we have it, but we're not going to give it to you because of ABCD. But if you say, have you done this? It's very strange. Actually, I filed an RTI in the Supreme Court for one of the habeas corpus papers that I was writing. is to understand how many habeas corpus petitions have been filed in the Supreme Court. The first time I filed the RTI application, I got a response saying this is not information because we don't maintain it in this form. You don't maintain it in the form that you're asking. Because I was asking them a data set, right? I was asking them for something like an Excel sheet that gives me just case numbers of all the habeas and I'll do the rest. They say we don't maintain it as an Excel sheet. They didn't say it's not creatable, it's not impossible. Or it'll take 1 or 2 clicks for them to export it into an Excel format and give it to me. But I filed the same RTI application 6 months later. The RTI officer had changed and then they gave me the information.
Yeah.
Stuff like this, I think technology can really help us with. It's not rocket science. If you have information stored in a particular electronic medium, yes, subject to safety security requirements that the government will have to implement. But if you can manage that storage of governmental information, which is public information, in some database somewhere, the procurement of it and answering of queries, and this is the best use case for a large language model to do. Right. So these are things that I think, at least so far as RTI, but they will never do it. Government will never do it because they know that at every step they want to have control over. Yeah. Because sometimes it may not be convenient that the information comes out. Yeah. And just imagine that, right, there's nothing else that sort of will make the RTI much, robust to its extreme.
Yeah.
You don't have to apply for it. You just have to ask a question on a computer. When was this person transferred from A department to B department? And there comes the answer. But yeah, of course, they will have to sort of have checks for the valid exceptions that are given in the RTI. So in some way, before storing the data, perhaps they can have a filter and this doesn't go through this goes through. But yeah, so that's one of the cases that I feel RTI,
Yeah, I think especially it automating something and that would immediately and by default remove a whole layer of sarkari bureaucracy where you aren't allowed to say anymore that this doesn't exist in a certain form, or okay, if you fill it in annexure A4, if it's not in that exact cookie cutter thing, I will refuse information, even though the word information, it's not a technical word, right? It's supposed to sure, legal jargon. And again, I think this goes back to your point about if you're not able to go back to the first principles of why that exists, and not necessarily purposive interpretation of it, but just the fact that RTI is for getting this information common parlance out of the system.
Correct. And common parlance is such an important phrase here, because you may get that information in some confused form from the government, but just by the intervention of this new technology, you can make it so much more accessible, multiple languages, whatever you want, really. Yeah, yeah.
Do you want to go on to the questions? Yeah. Okay. Yeah. So to wrap up our conversation, we've got some quick fire questions for you. You can answer them in a sentence or two.
Or I can refuse to answer.
Yeah, of course. Yeah. Yeah. They're not going to get you. They're not going to get you into trouble. Hopefully. So yeah, if the Indian Constitution was an app, what would be its killer feature?
Yeah, living tree. I don't know what it means, but yeah, living tree.
Okay. Your thoughts on paperless legal practice in 3 words.
Revolutionary, necessary. Yeah, that's it.
That's 2 words.
Yeah. I don't want to repeat. Yeah, revolutionary, necessary, important. Yeah.
Okay, if you could have any futuristic technology to help you in your legal work, it does not have to exist right now. See, what would it be? What's making your what's the biggest query, right?
Filing procedures. They don't have to be done at the lawyer's end at all. They have to be done at the court's end, according to me. What are the annexures? I should just upload all the annexures on the court's website. The court should figure it out. The court should have an automated system where the file is compiled together, and in whichever order you want to place my annexures, you place them, page number it as you want. You want A, B, C, D, want 1, 2, 2, 3, 4. You want Roman numerals. You do it, but don't task the lawyer with this sort of job. Very, very easily automatable. It's really, I mean, just waiting to happen. Okay.
So literally inhumane to make a person. So outsourcing.
Really, I mean, it's not inhumane. I mean,
No, I mean,
people
it's
have done it for
yeah,
many
but-
generations, but
Yeah.
it's
I
not
mean,
something human beings should be
so much
doing.
of a
Exactly.
technicality and
Yeah. I agree.
And usually it's the like empty that I'm happy.
Yeah.
You know.
That's right. That's right. Why flagging stuff? Why just I mean,
Yeah.
yeah. Okay, our last question is, what is your secret non-legal talent that surprisingly helps your work?
that I am sort of invested. Like, I had computer science as my additional course in 11th and 12th, and I know some coding.
Oh, me too.
So that really, I mean, you'll know that if you now want to transition to, so there was C++ when I was in school, they taught us C++, but so very, very similar to Python. And now if you want to code something that really makes your daily tasks quicker, it's very, very
Much
sort of
easier, yeah.
accessible. Yeah. And with AI, with the large language model helping you code it, it's even better. And you can do the small fixes yourself, because even if the large language model makes some mistakes, you can cure it. But I've made like small tools for myself and for some of my friends who were struggling to download. Sometimes you need, I mean, you're entering you're entering an existing matter for the first time.
Yeah.
And that matter has already had 150 hearings, already one of those batch matters. And now you want to know everything. So the first step is to download all those orders. You to go to the Supreme Court website, click, download.
That's a lot.
And do the capture.
Yeah, and do the capture. Now you have to do the capture. But a few months ago, the old website didn't have capture.
Oh, okay.
Or you go to other courts' websites. So for one court, I just made a tool that just automatically just download it.
That's really
Oh,
nice.
wow. And you built it yourself.
Yeah, I mean, I used ChatGPT to sort of help me. But it's all about prompting, right? You just tell ChatGPT that this is what I want. You just need to know basic elements of what is it that you would have done manually.
Yeah.
And you just need to think very carefully about if, for example, on the Supreme Court website, the orders tab is located here. As a human being, what is my brain doing?
Yeah.
My brain is taking me at a particular part of the page, clicking that tab so it opens up, and then all these links, then link by link, that sort of clicking. That's really what you have to tell the platform. Of course, you have to talk in a little HTML language to make it understand this is the frame I'm referring to, or this is the code I'm referring to. But yeah, that sort of head start, that's what I was talking about earlier also. If you encourage that kind of a culture, people are comfortable with technology. That can take all of us really far.
Yeah, that was going to be the last question. Just really quickly, because now I'm curious. Like, what's your, and I hate to use these words, but tech stack, right? Like your workflow. What do you like? What apps or applications make your life the easiest for your work? Because I know a lot of lawyers use like Obsidian, Notion, or whatever. Like,
yeah, no, I don't use Obsidian or Notion. I actually heavily rely on liquid text.
Okay,
liquid text is it's going to be the most common answer, I suspect, from most lawyers who are using digital files.
It's great.
Now. Yeah, it's fantastic. It's and I think liquid text makers have also realized that lawyers are our primary consumers, and they've now started adding features that are specific to law, right? They will tell us annexure numbers, they will tell us citations, they'll pull it out. So I don't know what all is going on in their minds, but yeah, liquid text really makes my life easy. And some of these tools that I keep making for myself to make sure that we are not missing dates. Like this one tool I had made earlier, but it stopped working because of some update in the way Google Chrome works. But I use Google Calendar to track my matters and dates. And sometimes the office staff it'll happen with everybody that, sometime one matter is just, just slips through the cracks. There was some tool that I was able to make where if I just open if I launch the tool, it'll go through my calendar, make a list of matters for which the dates have not been updated. And just tell me that, these are the matters you sort of missed. Yeah. That stopped working, and I'm yet to sort of get
Fix
back
it.
and make it afresh. But so stuff like that, I think technology generally really helps me. And these days I'm looking forward to maybe at some point when I feel financially, yes, now I can do it. There's a very famous software by a company called Nuance.
Okay.
The software is called Dragon, naturally speaking.
Okay.
Successful lawyers in the old days really relied a lot on it, like a dictation software.
Okay.
Nowadays dictation is actually very democratized.
Yeah.
On your
transcribe. Yeah.
you can just switch on the mic and start dictating. But the selling point of Dragon is that, especially for lawyers, it can learn commands like go back,
Okay.
or
Okay.
when I say honorable court,
Right.
don't write honorable,
Right. Yeah.
right? HON apostrophe
Yeah.
BLE.
Yeah.
Those small things, it's really smart in that sense. And this, I'm talking about the Dragon that used to exist 10-12 years ago.
Right. So now it must be a whole different animal.
Must be. And I can't
Yeah.
wait to sort of experience it, except it's insanely expensive.
Yeah, well, thank you so much. This was actually fantastic and actually way beyond our. Yeah, we were really happy with this, how this turned out, especially for a first episode. And we're really glad that we got to not just speak about like your views in the system itself, but also how you personally approach technology in your practice. And again, like this is March in Hyderabad on an afternoon in a room where the AC isn't working. So thank you so much for being so patient with us, especially immediately after a panel. And yeah, we hope that this is the start of an association and that we are able to revive TLF to the extent that we can, actually with confidence invite you and other speakers. Yeah, thank you so much. And